Eva set us up very nicely for this next panel talking about platform design. So this panel, we titled it Product Design for a Healthier Online Experience. So this last panel that Lisa moderated talked a lot about what do kids want with social media? Do they know what they want? What do parents want? And what are sort of the policy proposals floating around to try to answer those questions about kids' online safety. At the very end, when talking about what the panelists would like to see in new policy proposals, we heard some ideas about protections for all users, a little bit, some more user control over how people of all ages can design their own platform to fulfill their own needs. And for this panel, we're going to talk about what product and platform design could actually look like. We're going to talk about some of the product's liability lawsuits that are ongoing, why some of those have not found success and why some of them may find success. And then do some predictions at the very end. So again, in the last panel, Ava mentioned that predicting in the near future, there'll be a lot more focus on especially kids' use of AI chatbots and AI companions. So is there anything that we can learn from ongoing products liability litigation and product design thinking, and how can we apply that to this next iteration of kids' online safety questions? So before we dive into the real questions, I want to do some scene setting. So when I think about products liability and product design, I think of something tangible. You know, I think of kids, sort of child seats in cars or seat belts. But we're talking here is about something that's more intangible. We're talking about platform design. And so to start us off, I would love to hear from, actually, before we get into it, I need to introduce our panelists. I got ahead of myself. So my name is Morgan Wilsmann. I am a policy analyst with Public Knowledge, and I head up our work on healthy information systems, and I'll have my panelists introduce themselves and who they're representing.
Hi everyone, my name is Pamela Wisniewski. I am the director of the Socio-Technical Interaction Research Lab and Innovate. I'm also onboarding to ICSI, which is a nonprofit affiliated with UC Berkeley. Ultimately, I'm a human-computer interaction researcher who, in the last 13 years, has dedicated her research to working with teens and for teens for their online safety.
Hi, everybody. My name is Iorio. I'm Senior Counsel at the Electronic Privacy Information Center. I direct our platform governance and accountability work. I spend a lot of time coordinating and filing amicus briefs in various cases around the country about harmful platform design and online privacy. And I also give some drafting support to legislators who are looking to craft laws that address harmful design in a way that also preserves user speech and complies with Section 230, etc.
Hi, my name is Peter Chapman. I'm the Associate Director at the Knight-Georgetown Institute. We're a relatively new institute at Georgetown focused on connecting independent research with technology, policy, and design, with a specific focus on our online information ecosystem. Broadly, KGI works across two technology policy areas, competition policy and platform governance, where we take a specific design-based approach.
Great, let's dive into it. So to start things off, Pam, from your expertise, would love to hear, what are we talking about when we talk about product design or platform design?
Sure, and I almost reframed this question a little bit as, should we be talking about product design or platform design rather than user-centric and interaction design? And I say that because when we talk about product design when it comes to the internet, we often think about optimizing platform profits. engagement, which can turn into addiction, and then the stickiness of keeping users on that site to be able to drive profits. Everybody's heard that, we're just on the internet to drive clicks to ads, right? The problem with looking at it from a purely product design perspective is that social media platforms are not just driving our interactions as consumers with a product, they're changing our culture and our norms, and they're becoming part of our everyday existence. So we need to think about this more in terms of user-centric or interaction design. And simple decisions on a platform can drive behavior. For instance, the difference between allowing somebody to opt in to a certain service versus having them have to opt out makes a really big change in the amount of email that comes into your inbox. So if we think about it at that very more granular design level, the choices that these platforms make at the feature or design level really can change behavior in ways that can result in dark patterns or light patterns of how we interact with these systems.
Appreciate that. In terms of how policymakers and regulators and even the courts are looking at product design, we can dive into the particular cases in a little bit, but from a more general perspective, I would love to hear from, we can start with Peter, about how the policymakers and courts are looking at product design and platform design.
Yeah, I think your paper does a great job actually highlighting some of the major trends, both in Europe, UK, US, state level, and with courts, about how folks are starting to look at design. I think over the last 10 years, we've had debates around content moderation, debates around particular types of speech, and we've all encountered the challenges of actually navigating where to draw those lines. I spent some time at Twitter in their legal department, and the Twitter trust and safety teams would do sort of coding of different types of content with Twitter's policies. And we would see the vehement disagreement amongst the teams actually responsible for enforcing these policies and writing these policies of where particular types of content would fall. And so I think that with the rise of polarization and sort of the focus on technology platforms, I think has pushed more folks to look at the actual fundamental roles of design in shaping our online experiences. And when you look at legislation, increasingly legislation is incorporating design-based approaches. The first panel talked about the age-appropriate design codes, but I'd say most legislation at this point is incorporating elements of design. So there's a big debate around the DSA here in DC with Jim Jordan hosting a hearing last week on the DSA and implications on American innovation and free speech. There are certainly aspects of the DSA that focus on dimensions of content, notably the orders for legal content. But if you look at the whole bill, it actually incorporates quite a lot of design provisions around protection of minors, around recommender system design, and ultimately the approach it's taking is more transparency in those design processes and requirements for risk assessment to actually interrogate the design. And I think similarly with litigation, we've seen an evolution, which Megan can certainly talk in detail about, around claims around specific types of content, much more to the actual design features of these platforms and what they are actually optimizing for. So just to take an example, I think over the last 2 years or 3 years now, about half of the state's attorneys general have sued TikTok. And if you go back and look at the TikTok complaints from sort of late 2023, early 2024, you see a lot of elements of those complaints that are focused on particular types of content that the AGs are more concerned about. The role of content glorifying sort of self-harm or content related to extreme dieting or eating disorders. And where you see the new complaints, and just I think 2 weeks ago, the Attorney General from Minnesota filed a new addictive design complaint against TikTok, Massachusetts, others. If you look at those complaints now, they're much more focused on the actual design elements of the platform that are related to extended use. So what is the timing and clustering of notifications look like? What are the sort of frictions in one's social media experience, endless scroll, autoplay? All of these elements which the attorneys general are alleging are design choices the platforms are making that are actually influencing user behavior and driving folks towards addictive or excessive use. So I think we're sort of seeing certainly a greater focus on design, and I think part of that is just the sort of legal feasibility of those types of claims, whether that's in regulation or in a lawsuit. But also, from an effectiveness standpoint, I feel like people are acknowledging and policymakers are acknowledging the need to move upstream to address some of those sort of root causes for some of these downstream impacts.
I think we should dive in a little bit more about the specific litigation. So a few years ago, we can think about what happened with Gonzalez v. Google. In that decision, the case was determining whether or not the algorithm serving an individual content is liable for radicalizing that person to committing real-world harm. Decided that in that case that YouTube and Google Alphabet is not liable for that. We can talk about why. But as Peter mentioned, we've seen some evolution of how we approach these cases. So the list is pretty long about what these cases look like these days. There's the multi-district litigation that is in California right now. It scoops up many different defendants, meta platforms, Snapchat, TikTok, other social media platforms, alleging that these platforms are defective because they're designed in a way that perpetrates harm to its child users, addictive behavior, for example. And then there are other cases, like the Anderson v. TikTok case, where a young girl, 10-year-old girl, died after attempting a blackout challenge that was fed to her on her TikTok page. And there's lots of other cases like this. We hear about subway surfing challenge, and it goes on and on and on. And while these cases are ongoing, you would think, okay, so if a child sees this idea on a platform, should the platform, or does the platform have any liability here? Should they be held accountable, and how so? So these cases are ongoing, but I think this is just a bit of a very brief overview of what they look like. But I would love to hear from Megan. How do you see this current wave of product liability lawsuits potentially reshaping sort of the legal framework for platform design decisions?
I think that, first of all, as you were just outlining, Morgan, there's a wide variety of litigation out there targeting platform design, and some of the legal theories are more coherent than others, and some face more of an uphill battle on various legal doctrines that we have in the country. So we have to step back a little bit from just the specifics of the cases to look at like various different layers that are really happening in these cases. And then once you can filter through all these, you might like wind up with some potential for like leading us toward some kind of design legal framework. So first you have the actual legal claims and whether they're meritorious. In the Google v. Gonzalez case that was brought up to the Supreme Court on Section 230 grounds, the Supreme Court wound up getting rid of that case actually based on the fact that the plaintiffs hadn't stated a meritorious claim. They had said that alleged that the companies had forget exactly what it was, essentially like aided and abetted terrorism by having their recommendation algorithms publish certain content related to Hezbollah, Hamas, or something like that. And in a separate related case, the Tamnick v. Twitter case that was decided at the same time as the Gonzalez case, the court said that just publishing this content through a kind of like neutral tool, a algorithm that wasn't designed to specifically pick out terrorist content and to promote it, that is not enough to state a claim of aiding and abetting terrorism. And didn't touch the Section 230 issue. And that's the way it should have been decided. But then, if you have various other cases out there, like the Anderson case, for instance, that states claim, maybe not, I don't think the court even decided that, and then decided the Section 230 issue, in a way that probably would wind up then leading the court, if the case had gone forward, to finding that actually the First Amendment blocks liability in this case. And so the point of all of this is just that there are a whole bunch of like layers that all this litigation has to go through, and they're all going to go through it differently because they all have different claims. They're all focused on different design practices, and possibly they're not even focused on design practices, they're actually focused on content, like Pete was saying. And the most promising cases out there are I think the Attorney General cases against the Meta and TikTok and Snap for addictive design. And that's because these cases are stating claim they're under the state UDAP laws, which are unfair deceptive trade practices. And essentially they're saying that the way that these companies are designing their products undermines kids' autonomy, their ability to get off and stay off the platform, to decide for themselves how much time they spend there. That leads to problematic use of the platforms. The companies know this. They make choices to do this. They have other choices to make, and they focus on content-neutral design elements like autoplay, infinite scroll. Some of them focus on aspects of the algorithmic recommender system. Some of them don't. But they do it in a way that is much more likely to be able to filter through Section 230 and First Amendment claims and lead to regulatory options that will preserve speech, preserve privacy, and can hold up in court.
Anything to add from
Well, I think I'd like to add a perspective that's like outside of the legal frameworks, because I mean, honestly, I think the stuff that's going on from the legal side and the policy side is amazing, but I think some of us might be a little left behind. So I'll try to say this through storytelling. I was first approached in 2020 by a law firm who was trying to file a mass civil tort against some of the big social media companies, framing the evil algorithms akin to vaping and addiction. And back in 2020, I just point blank said, well, that's just stupid. Like, what about the algorithms? Like, you need to like give specifics. And what about the design of the platforms, like the features that engage addictive behavior rather than just the algorithms? As you can imagine, they never called me back. But a few years later, I kept getting calls from the MDL, the multi-district litigation, from both the plaintiffs and the defendants' sides. And what I learned as somebody who's like a layman, who's a researcher, that they were approaching as an expert witness, is that ultimately they were trying to solve a problem that we all know is a problem. But in the US, they're running up against barriers with First Amendment rights to free speech in Section 230, which basically just says that the platforms aren't accountable for the user-generated content on their platforms. And therefore, they started moving these discussions to the things that would stick, which are the ways that the algorithms are biased or influence behavior, and then the design-based features, which, like I was glad that they cut up to that, such as infinite scrolling, privacy defaults, and other things that influence behaviors in potentially deceptive ways. And so I think that's why we see that the legal landscape's going the way it is. And what we also see from the industry, kind of the big tech side of things, it are two other, I guess, patterns. One, for youth, they're really pushing towards parental control and parental consent to be able to shift the liability to parents for the kids being on these platforms. And we also see other things that are guised as privacy protective, like end-to-end encryption, that would then make the companies not culpable in knowing some of the harms of these platforms. And so when we think about what's happening in the legal space, and I've learned a lot of terminology like colorable and actionable claims and things like that I didn't know before I started talking to people in this policy and legal space. I think that's really where some of the discussions are coming from the legal side and legal frameworks and policy and regulation, and the folks of us who have been working on the design side, and knowing that there's things that we can do in design that could potentially protect people proactively rather than taking this as a risk-based framework of trying to retroactively, protect the kids online. So I just wanted to kind of put that translation of some of the things that have been going on from the layman's perspective versus what we see kind of at the policy and legal levels. Appreciate that.
Yeah, and I might just add, I think it's interesting to see like the Attorney General's offices at the state level involved quite actively, obviously the litigation, but also the regulation. So I think, and also the regulation is being challenged on legal grounds that navigate similar thickets around Section 230 of the First Amendment. So in terms of your original question about how is it shaping the environment, it's definitely a conversation between litigation and regulation in my mind. And I think in terms of impact, these cases don't have to be sort of successful on their merits to be impactful, in my view. And I think if you look at some of the other sort of mass tort kind of claim litigation, whether that's tobacco or opioids or vaping, you've seen cases move forward that didn't actually result in a judgment, that set the sort of shape of regulation of those industries. And I think what's particularly interesting in some of those is the tobacco industry had been challenging advertising restrictions in court. The Master Settlement Agreement introduced some advertising restrictions. They weren't exactly the same, so we can't say they introduced provisions that would not have been allowed under the First Amendment, but they were certainly adjacent, as I understand it. And the company said, sure, we'll stop targeting kids with advertising. We'll stop cartoons. We'll change the way we advertise with sporting events, etc. in that settlement agreement, and that changed the way that the industry operated, irrespective of a final judgment in that case. And I think there are lots of other ways that settlement remedies and sort of injunctive relief can do similar things in the technology landscape. That doesn't mean that all of these cases get to final judgment. They're all going to be appealed anyway, depending on how it goes. It's a multi-year process, but I think it's clearly going to be extremely influential in the U.S. jurisdiction, whereas some other jurisdictions are pursuing more sort of ex-ante regulation.
So to summarize, Megan talked about how originally many of these cases ultimately boil down to whether or not it's about content, which is Section 230 of First Amendment protected. And later, as time progressed, there are new strategies where, as Pam mentioned, design thinking converged with these regulators and policymakers and lawmakers, and those the lawsuits themselves as well. And we're at this point now, this convergence, hence the topic of this conversation. But I think we're still very early on in determining what exactly are these particular features that are determining or causing harm that we're speaking of. And so Pam, I would love to hear from you, based off of the conversations that you've been a part of, that you've been monitoring, do you have perspectives on other things that lawmakers and regulators are looking to that might be overhyped or maybe they're overlooking? And from your research, how are young people actually engaging with these features?
Sure. I think the myth that is most dangerous right now is that social media bans for youth will make them safer. Because from a legal perspective, it won't, because then they can claim that they don't knowingly have youth on these platforms, which we all in this room know they will. And by being able to claim that, they no longer have to embed safety considerations into the design of these platforms. So just as a personal example, my 10-year-old daughter still uses YouTube and also goes on my Facebook account. But in the last year or so, the ads on these platforms have actually gotten worse than they were before, mostly because of the claims that these social media platforms are pushing younger kids off of the platforms. So we really have to think about how bans and regulation are translating to actual use and experience for our children. The other thing that I think regulators have been struggling with is we have created frameworks like age-appropriate design, but then we're moving into the slippery slope of age assurance and age gating. There's a really big difference between age verification to make sure that youth are not accessing content that's illegal for them to access versus age gating social media platforms that infringe on their First Amendment rights to access. And there's also a really big difference between using actual age verification practices versus age prediction. So they're using technologies to create algorithms to predict how old somebody is on these platforms, when in actuality you can't do that with any air of accuracy or precision that doesn't unintentionally harm people, such as individuals with developmental disabilities such as autism. So we really need to think about how we're implementing some of these design choices in ways that can unintentionally harm individuals who are already disproportionately harmed on the internet as it is, and ways to do it thoughtfully and intelligently. Like for instance, having good privacy defaults on the platforms is a good trade-off of being able to protect people de facto at the beginning, but also giving them the autonomy to override those protections so that it's not restricting their digital rights. So thinking about it from these more nuanced perspectives, and another thing that I loved in the report is we need to do this at the feature level and looking at it from the risks posed to youth, not thinking of social media as this monolithic of like, should they be on the platform or not, and thinking about it from a content regulation perspective.
Going further into some of these policy proposals, I know that you've done some work around age-appropriate design code. I would love to hear your thoughts about the evolution of that, being introduced in various states here in the U.S. And then perhaps if you could answer the same question about is there something that policymakers are overlooking?
Yeah, so this might be a rehash of information you already know, but the age-appropriate design code came to the U.S. from the U.K. A group called Five Rights brought it to California, and it didn't really attract much attention when it was in the legislature and wound up passing, and was really in the litigation that it attracted a lot of attention. It was Net Choice's first big challenge to a kid's online safety law. And this litigation has been shaping the subsequent versions of the age-appropriate design code since then. In somewhat helpful and somewhat not helpful ways. The district court judge in that case doesn't really understand the First Amendment very well, and so it's been like somewhat of a ordeal. But it has given us like ideas about how judges look at kids' online safety. And so the California version of the age-appropriate design code took, what's funny is an approach that some members of the previous panel actually said that they would like to see moving forward, but was actually the basis for challenging the law, and that is a risk-based approach to determining what a company must do to protect kids. In particular, the age assurance mechanism in that law was explicitly risk-based, that companies were to adopt certain measures to determine like who's a kid based on the risks that kids face from the company's data practices. And so NetChoice attacked this law as being too vague and essentially used the standard-based way that it's written against it by saying that it could be interpreted in all these different ways. And no court had interpreted it yet, so it's kind of a mess. And so that litigation has led policymakers to choose a different path, which is to focus more specifically on design features that are known to be manipulative, to lead to problematic use, to cause various other harms like lead to unwanted adult contact, to interrupt kids' sleep, et cetera, et cetera. And I think that, and that's the approach that the latest versions of the age-appropriate design code in Vermont, for instance, that I gave some assistance to take. And in this way, as we've been already discussing here, the hope is, one, to be able to survive a legal challenge from NetChoice that will ultimately come about, but also to just be more effective, right?
Pete, I would love to hear from you. Beyond just the AADC, are there other design-based proposals being pursued or could be interesting?
Yes, I mean, as we heard in the morning's panel as well, I mean, there are many dozens of state-level bills. There are also, those federal proposals that were called out. And then around the world, we're seeing a multitude of design-based regulations as well. I think that the challenge of articulating where that line is, like risk assessment, for example. In the Digital Services Act, risk assessment is designed for a risk-based approach to mitigations, right? So every year, very large online platforms have to do a systemic risk assessment. That risk assessment is part of the audited obligations under the Act. They're required to put in place effective mitigations in response of that assessment. So that has sort of been one toolkit that also drew on the age-appropriate design code, and I think your paper sort of also suggests linking sort of design-based approaches to foreseeable risks. And I think one of the ironies of this is that platforms have been doing this for a long time. I mean, Meta has a human rights team. They had a responsible innovation team whose job was to help product designers assess risks to particular marginalized groups upstream in the design of their products, and then manage those risks more effectively as they ship their products. Not stop the product from being shipped for the most part, but make some few changes to protect marginalized users who may be impacted in specific ways. TikTok still has a responsible innovations team, as I'm aware. So I mean, there are internal teams in platforms doing these at the same time that the industry is challenging these design-based regulations. So I mean, there's something we can unpack there, obviously, around the approach to regulation. I think KGI, we've worked around engagement-based algorithmic systems. So if you look at some of the regulatory proposals at the state level as well as internationally, you sort of would look at kind of two options for a feed. It's either you have a non-personalized chronological feed that's mandated to show your, what folks you follow in chronological order, or you can have a sort of feed that is maximized towards engagement. And we convened an expert working group and put out a paper called Better Feeds, which looks at this vast middle ground between those two options. So how can you actually leverage the benefits of personalization, give users actual control and agency over their online experience, and open those feeds up in terms of transparency to understand how they are designed to let users, consumers, actually have an understanding and a choice in what they want to use. And so we focus in that paper and with those recommendations a lot on those user controls and defaults, as Pam was saying as well. Like whether you decide to opt in or opt out is a hugely consequential decision, particularly because most people don't change their defaults. And we feel like that's a place actually where regulators can be quite influential. So not saying you have to do this for all users all the time, but if you're a minor, you should be opted into a safer experience. If you're a regular user, you should also be opted into that safer, more privacy protecting default.
Do you want to respond to that?
No, I mean, I really like the idea that the design choices that we can make to protect children online are often design choices that are also healthier for adults. And I think that's one of the cart and the horse type of problems that we're having right now is that these discussions have teeth and are consequential for children. And so I think that's why we kind of focus there, because everybody says, well, hey, don't limit my rights because I'm an adult and I can do what I want. But if we think about a safer and healthier internet for all, it doesn't necessarily always have to be just related to the children. And we have to be careful when we make it a discussion just about children, because there's people out there who don't believe that children have any digital rights or freedom to expression or speech. And we have to be careful that those people don't take that overly protective lens and unintentionally harm our youth by doing things that are not developmentally appropriate for their development into adulthood.
Curious from Peter or Megan, if you were to respond to some lawmakers who knee-jerk reaction, like sit in our hallway to say, okay, Section 230 protection's gone because of this, or any sort of other reaction. I'd love to hear from you. What you would say to them?
I mean, on the Section 230 point, I mean, I think as I understand it, like Character AI and Google did actually not raise a Section 230 defense in the Character AI case. And I guess, I mean, from my perspective, like we're seeing attorneys general act. I mean, we've seen maybe you've seen the letter that they sent to OpenAI, but also other companies in response to the ChatGPT case and Adam Rain's death by suicide. Also, the sort of release of the documents that Reuters released, Jeff Horowitz released. Like I think, from my perspective, like Section 230 is probably not the place to start for this conversation, and I'm actually heartened by the fact that it doesn't seem that the attorneys general are starting there either. Like I think there is a sort of statement around the focus on design of these platforms. So both how is it responding to prompt responses, and then what do those responses look like? To what degree are those responses seeking to extend use? In what ways? I've heard anecdotally that like factuals or homework-based questions receive very different desires to pull out additional personal information from a user than the emotional sort of support uses. Why is that? That's a design choice. Let's understand that design choice. And I think it also calls attention to me about the sort of insufficiency of these companies making these choices by themselves. I mean, I don't think anyone could have read that meta content policy and felt like this was the proper line to draw. And I mean, the company obviously felt the same way in the end because they said this was the wrong version and we've taken out these examples. But individuals are making these decisions in companies proactively, and I'm heartened by the speed in which it seems that the legal community is saying we're watching these decisions being made, and it's taken many, many years for lawsuits to emerge in the social media space, and we've seen these lawsuits emerge in the generative AI chatbot space in a matter of years. Obviously that does nothing for Adam Rain's family, his circumstance, but I hope that we can move more quickly to think about how these products are designed and the safety measures that need to be embedded in that design to protect American consumers and consumers around the world.
Yeah, I mean, I would add, one, at a very high level, the issue that we're facing with chatbots is very similar to the one that we're facing with everything else that we've been talking about today, and that is companies are releasing these products without sufficiently assessing for risks, and also without caring really about it. And so this means there needs to be regulation. And then I would add one thing is that also some of the like design code proposals or laws that have been recently enacted, some of those provisions would apply to chatbots. For instance, in Vermont, there is a duty of care that requires companies to, would hold companies liable for reasonably foreseeable compulsive use. And that provision could also be used in the chatbot space where companies are making explicit design decisions to make the chatbots more engagement-based. And there are various other like aspects of it that could apply as well. But
so this is not something that we touched on in our paper itself, AI regulation. But we know this administration at least has attempted to implement an AI moratorium at the state level and is very adverse to AI regulation at the federal level. Do you think in the last few months maybe that calculus has changed a little bit now that we're seeing these horrific headlines, or just out of curiosity, or if it's status quo, same thing?
A colleague of mine was at NCSL, and I feel like the sort of conversation of the AI moratorium here in DC is very different than state capitals in terms of enthusiasm around that moratorium. I think that's important to call out. I also think that many of the harms we just were discussing, like it doesn't require new regulation. Like in terms of these product-based liability claims, like these are products these companies are putting into the market that are having these risks, and they can be held liable regardless of whether there is a new law. And so I personally don't think that safety in this space has to be tackled at a federal level from AI law. Like I think there's a lot that can be done across the country in the near term. And Vermont has a private right of action in that law as well, right? I mean, so that what you just were saying, like any family in Vermont suffering these circumstances now has a right to actually tackle that without the Vermont Attorney General.
So to expand on this, so Megan just discussed at how we're in uncharted territory and it may require some new regulation, but at the same time, there's some existing law that we can already lean on. Megan, what is that? Do you have an idea of what that regulation could look like at this point?
sorry for being repeat for.
Oh, so you mentioned that because we're in uncharted territory. Well, I think those are my words. In terms of these new technologies, I think you mentioned this is a space where it might get some regulation. Do you have any specifics about what that could actually look like?
About chatbot regulation? Yeah, that's something that we're thinking about right now. The thing is that it can take a lot of forms, but I think that the lawsuits that are currently out there against Character AI and OpenAI give like a pretty decent framework, at least for like certain harms, right? One would be that when it comes to users who are engaging in like suicidal type of ideation with a chatbot, to have like the conversation like completely cut off, to make explicit that the duty to consider reasonably foreseeable compulsive use applies to chatbot design. There have been some proposals that, some information out there has actually made it seem like the engineers might not actually be able to prevent the chatbots from like doing some of the harmful things that we've outlined, especially with like the suicidal ideation. There's information about OpenAI saying like, we tried to get this stuff, but it went in a direction that we didn't foresee because they don't really understand how their own products are working.
Right.
And so that could also lend in favor of perhaps, minors shouldn't use this for now. We should have a moratorium on minors' access to chatbots until the chatbot companies can figure things out. I think also risk assessments and are really important in this space. It's like a baseline thing that people mentioned. Companies typically having themselves support having frameworks for risk assessments, but there has been such a pushback in the states that have proposed risk assessments for AI from corporate lobbyists that they haven't been able to pass.
I have one small point. So I'm not an attorney, and so the regulation and legal stuff kind of evade me sometimes. But putting on just my observation hat of sitting on DARPA ISAT, the study group, a lot of the legislation in terms of the moratorium against AI is really coming from the Trump administration recognizing that China has outpaced us in the arms race for AI, and therefore they don't want to put regulation on it to stymie innovation. And so this is coming from a bigger political, geopolitical space that the kids are kind of getting caught in the crosshairs, right? But we also see that the Republican Party is also fighting against this in the space of kids, with Marsha Blackburn being one of the proponents of being able to make state-based regulations and not having the AI moratorium. And so I think what we're going to see is that this larger debate on how and if AI should be regulated in the U.S. Is going to be driven by whether or not and how this is having an effect on our children. And so that's why the people in this room are really going to be pivotal in talking about some of these policy and regulation-based things from the perspective of protecting youth. And I think that was something that I didn't realize until we were talking about national defense and how we're going to use AI and how we can't use AI because it hallucinates and makes stuff up. But the fact is that that's the direction everybody and their brother is going right now, is AI for everything. And as a society, we're all going to have to figure out what that means for humanity.
So, don't want to keep you all from lunch. I know this was a very relatively heavy topic, but to close out very quickly, if you could, in one sentence, or as close to one sentence, define what you mean, what safe by design means to you. So we can start with Pam here.
Well, I'll go quickly because I actually have a handout that I gave that they have that everybody can pick up. The idea of safety by design to me was something that I was conceptualizing from the privacy by design framework back when I wrote my NSF Career Award in 2018. And the idea here is to be proactive in our design choices so that we're protecting people as we're building and designing a product, rather than trying to retroactively protect people and once there's been harm done. Right now, we have a lot of mechanisms to report problems after they occur, and then we find that these platforms don't do anything to protect youth. So really trying to take a user-centered, teen-centric approach of building in safety mechanisms to these platforms to help empower them as a way to regulate risks. Because safety doesn't mean the absence of risks. It means our ability to be able to manage these risks effectively.
Yeah, on that vein, there's always more than one way to design something. And right now, the companies are always choosing the way to profit. And there are lots of other ways that also can protect kids from certain known harms. And so Safe by Design is getting companies to make that second choice instead of always making that first one. Doesn't mean that their companies are not going to be profitable. They absolutely can be. But that they choose instead to mitigate harm.
I don't think I have much to add. I would use many of the same terms. I think this focus on the user focus as well as proactivity, I think, are two key elements.
Fantastic. If you haven't received it, at the very front, the table is Pam, summary of Pam's work she just referenced. But otherwise, join me in giving a hand to our panelists here.